Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I'm Mark Solomon, a defense attorney in Denver, Colorado. And today's question, with the Derek Chauvin trial having concluded a week and a half ago and his lawyers asking for a new trial, what is juror bias? What is juror impartiality? But before we get to that, don't forget to click like and subscribe and the little bell next to it to be notified of future videos if you would like that. So, juror neutrality, juror impartiality, and juror bias. Let's talk about that. First off, what do these words mean? To be impartial means you don't side with either side at all. You don't come into the trial with any leanings whatsoever. To have bias is where you do have some sort of like or dislike towards something going into the trial. And that way you're less able to fair and accurately listen to the evidence and render a decision neutrally. So what we look for in a jury trial, what we look for in a juror is a lack of bias, and we want them to be impartial. So we had some questions about those on last week's video, and a lot of comments, a lot of questions about people saying, what does this mean? What does it mean to be impartial? What does it mean not to be impartial? What does it mean to have bias? Well, let's take a look at Colorado statute. That trial happened in Minnesota. We are not talking about Minnesota law. We're talking about general principles of juror selection and how it relates in Colorado. So let's take a look there. So this is the jury statute of how to pick a juror in Colorado. There are two types of bias in Colorado by statute. There's implied bias and expressed bias. So the jury statute in Colorado breaks that into those two parts. They don't call it that, but that's literally what it's doing. Implied bias is something that you just have because of your relationship to somebody, your past dealings with somebody. If you know somebody, you're just assumed that either you have bias or the impression that you have bias is so great that you cannot have a fair trial with this person as a juror. So let's take a look at the statute and we'll see how that works in this first section, right? So in other words, the jury, the court shall sustain a challenge for cause upon any more of these grounds. These are the implied bias: a relationship to a defendant or attorney of record, standing in relation as a guardian or ward, as an employee or landlord, employer, tenant, debtor, creditor, or principal and agent, and so on with any defendant in the trial. D, a juror has been a party adverse to the defendant in the civil action. Think about that. If you've sued the defendant, you're just impliedly biased against that person because you've sued them before. How could you then sit on a trial to decide whether they're guilty or not guilty of a criminal case? If they were on the grand jury, if you were a juror at a former trial in the case of a retrial, same thing if you were a juror in a civil trial with the same action. If the juror was a witness to any matter, that's why judges always ask whether or not the people on the panel, the prospective jurors, were a witness to any of these crimes, whether they knew it or not, because at this point in jury selection, the judge can tell them when and where this case happened. If the juror occupies a fiduciary relationship, any way where the defendant could be in some way financially dependent to the juror, or the juror could be dependent to the defendant. That is definitely implied bias. And this last section, which is section J, I take that back. Let's go to K. If the juror is a compensated employee of a law enforcement agency or a public defender's office, the law enforcement agency includes the district attorney's office. So in other words, if you're a state paid public defender or a state prosecutor, you also can't be a juror in a criminal case. It's just not going to happen by statute because you have implied bias for or against the state's case. Let's talk about this last one, J. The existence of a state of mind of the juror evincing enmity or bias towards the defendant or a state. Now, this is expressed bias. This is not implied. This is what these are the things that the people say in jury selection or in response to voir dire. So if you say something like, I don't believe police officers because I just don't think they ever tell the truth, that would fall under this subsection J. And that's where the jurors, the attorneys get to talk to the prospective juror and find out exactly what they believe. The judge gets to ask questions, and at the end of the process, there can be a 4-cause challenge for bias based on what that prospective juror said. Now, the next to this, I'm going to read it. The next part of this is no person summoned as a juror shall be disqualified by a previously formed, expressed, or opinion with reference to the guilt or innocence of the accused if the court is satisfied with the examination of the juror that he will render an impartial verdict according to law and the evidence submitted to the jury in trial, which is why lawyers always use these phrases when talking to the jurors. Of course, I always think it's a useless question to ask a juror, can you make a fair and impartial decision based on the evidence you heard? Another way you could just ask somebody, are you prejudiced? And pretty much the answer to that's almost always going to be, no, I'm not. Okay. Last thing I wanted to talk about in the Colorado statute, which I think should be in every statute, is if the juror knows of anything that would disqualify him as a juror, which could be a ground for challenge for cause, it is his duty to inform the court. Why is that important? It means, at the end of most every single jury selection, I always stand in front of them and I say, is there anything that somebody that you want to tell the court, anything that we should know about you as a juror, anything you've been just aching to ask or to tell us, but we just didn't ask the right question? Now's a great time to do that. Okay. I don't generally hear too many judges do this, but it says here in the statute, the jury panel shall be advised of this duty and the grounds for challenge for cause before any prospective jurors are called to the jury box. So in other words, the fact that they have a duty to disclose things that show their bias, really important. The fact that I always ask it, it's always good because that way it's a great reason for appeal if the case results in a conviction and we need to appeal and we find that one of the jurors was not being honest or forthright with his past or his actual beliefs and biases. So in other words, relating that back to the Derek Chauvin trial, if the juror who was later seen to have been wearing a BLM t-shirt, which really does seem to indicate a strong preconceived notion that police are doing the wrong thing, since the entire movement is that police are being racially prejudiced against suspects, especially black ones. And in this case, it was a case where a police officer was charged with murder of a black suspect, which seems highly, highly, highly relevant, highly, highly prejudicial against Mr. Chauvin. But I don't know any more facts than what I've seen in the news. So that's what the appellate courts will be deciding. So this has been a long video. So it was a good question, and we talked about this on the videos. Look at last week's. I'll try to put a card up so you can take a look at those comments and answers that we put online last week. But either way, that was the question and answer for today. If you would like your own question in future videos, don't forget you can always put them in the comments below. Tag me on Twitter or email. And as always, you have a right to remain silent. If the police officers ask you questions about what you've been, where you've been, who you know, anything, you have a right to say, I don't want to talk to you. And if they persist, I want a lawyer. Thank you so much for watching. Thank you.